Hello, you're now listening to the February 2021 episode of my PIP Monthly. My name is Amber Rouse Holloway, and I'm a partner here at Seacrest Wardle at our Troy office. For our February 2021 topics, we're of course going to discuss some new case law, starting with Michigan Spine and Brain Surgeons v. Homeowners Insurance Company, unpublished. Then we'll move on to Roberts Orthopedic Services v. Allstate Insurance Company, also unpublished. And lastly, the case of Midwest Medical Associates v. Liberty Mutual Insurance Company, which is also unpublished. As for trending topics in PIP litigation this month, we will discuss the scope of chiropractic practice pursuant to MCL 333.16401 and its effect on MRIs. First up is the case of Michigan Spine and Brain Surgeons v. Homeowners Insurance Company. Ultimately, this case expands on the doctrine of res judicata and how important it is to assert fraud in an underlying PIP case in order to do so in derivative cases such as provider suits. Here, defendant failed to assert fraud in a PIP case against the underlying plaintiff and instead just outright settled the case with the plaintiff. Defendant was then barred from raising the issue of fraud against an assignee plaintiff, here Michigan Spine and Brain Surgeons. Plaintiff appealed the trial court's order granting summary disposition in favor of defendant due to defendant's arguments that the named insured, Amelia Hosey, committed fraud. As a brief background, Amelia Hosey was involved in a motor vehicle accident. She made complaints of headaches, neck and shoulder pain. She was covered by a homeowner's insurance policy. Of course, the policy had a fraud provision that indicated that it will not cover any person seeking coverage under this policy who has made fraudulent statements or engaged in fraudulent conduct with respect to procurement of this policy or to any occurrence for which coverage is sought. Of course, Hosey applied for PIP benefits from the defendant. In her application, she described her injuries again. She indicated that she had not experienced the same or similar symptoms before this accident and that she had never made a prior insurance claim. She also sought reimbursement for replacement services that she claimed she incurred. Hosey underwent a surgery with plaintiff, and thereafter Hosey filed a complaint against defendant when defendant denied Hosey for benefits, and that lawsuit was settled. Then plaintiff filed suit due to the surgery that Hosey underwent, and defendant filed a motion for summary disposition asserting that Hosey misrepresented her need for replacement services, her pre-existing medical conditions, and the fact that she had indeed made prior insurance claims. The court agreed with defendant that Hosey made those fraudulent statements and granted the motion for summary disposition. Of course, the appeal followed, and Michigan Spine and Brain Surgeons essentially argued that there was no genuine issue of material fact that Hosey made fraudulent statements. Of note, the court made a very detailed argument regarding assignments and assignees. The court brought up the Burkhart v. Bailey case and indicated that as an assignee of Hosey, plaintiff stands in the position of Hosey, possessing the same rights and being subject to the same defenses. Plaintiff made 3 arguments on appeal. 1, that the trial court erred by concluding that Hosey made false statements. 2, that the trial court erred by rejecting plaintiff's argument that rescission was inappropriate as plaintiff was an innocent third party. And 3, that defendant was barred under res judicata and collateral estoppel. First, the court addressed plaintiff's argument that it was an innocent third party. The Court of Appeals highlighted that plaintiff, as an assignee, was subject to the same claims and possessed the same rights as Hosey, and thus Hosey was subject to the fraud provision in the insurance policy, and therefore plaintiff was as well. The Court of Appeals shut down the argument that plaintiff was an innocent third party, and then moved on to plaintiff's next argument that Hosey made false statements. The court concluded that Hosey did indeed make false statements. There was evidence that she had indeed made prior insurance claims. There was evidence that she had indeed suffered from the same or similar injuries prior to this accident. But the court did give plaintiff somewhat of a leeway with regard to Hosey's claims for replacement services, and indicated that the surveillance video did not necessarily establish as a matter of law that Hosey committed fraud. Nevertheless, with regard to her prior insurance claims and prior pre-existing history, she committed fraud. And now moving on to the doctrines of res judicata and collateral estoppel. The elements of collateral estoppel are: 1, a question of fact essential to the judgment must have been actually litigated and determined by a valid and final judgment. 2, the parties must have had a full and fair opportunity to litigate the issue. And 3, there must be mutuality of estoppel. The Court of Appeals argued that plaintiff's argument that defendant is barred due to collateral estoppel fails under the very first element, which is a question of fact essential to the judgment must have been actually litigated and determined by a valid judgment. And the court noted that because the issue of whether Hosey made false statements was not actually litigated in the lawsuit between Hosey and defendant, it wasn't actually litigated and not determined by a valid and final judgment. Therefore, collateral estoppel couldn't be applied. Now moving on to res judicata, the elements are: the prior action was decided on the merits. 2, both actions involve the same parties or their privies. And 3, the matter in the second case was or could have been resolved in the first case. With respect to the first element of res judicata, the Court of Appeals argued that a settlement agreement is treated as a decision on the merits. And with respect to the second element, an assignee is generally not treated as being in privity with the assignor for purposes of res judicata. However, in the case of TBCI v. State Farm Mutual, the Court of Appeals concluded in the context of a provider-assignee relationship that such provider is in privity with the insured assigner for claims under no fault. Therefore, plaintiff was in privy for Hosey for the purposes of res judicata. And under the third element, the court indicated that defendant now seeks to assert a defense against plaintiff provider that it could have also asserted against Hosey. Therefore, the settlement between defendant and Hosey barred defendant from asserting the issue of fraud against Hosey. Therefore, defendant is also barred from raising the issue of fraud against plaintiff, Hosey's assignee, who possesses the same rights as Hosey, who is protected by res judicata. So because that settlement was entered into, and now Hosey herself is protected by res judicata, plaintiff is also protected because they are in privy and an assignee stands in the shoes of an assignor. And moving on to the second case, Roberts Orthopedic Services v. Allstate Insurance Company. This case is almost in direct contrast to the prior case of Michigan Spine and Brain Surgeons v. Homeowners Insurance Company that we discussed. Here, plaintiff argued that the trial court erred in finding that a federal court's order in the underlying PIP case, which granted summary disposition to the defendant, barred plaintiff's claim against defendants under the doctrine of res judicata. Ultimately, the Court of Appeals affirmed the order of summary disposition in favor of the defendant. By way of background, in the Roberts Orthopedics case, Danny Omar was a passenger in a vehicle being driven by a Marletta Boyd when the vehicle was hit by another car. Omar then started treating with plaintiff Robert Orthopedics for his injuries. Because he did not have an insurance policy at the time of the accident, he then submitted his claim to defendant Allstate under Boyd's policy. Omar then sued defendant. Thereafter, defendant removed the case to federal court and filed a motion for summary judgment, arguing that there was no genuine dispute of material fact that Boyd's policy was obtained through material misrepresentation, and as a result, Omar was not entitled to recover no-fault benefits. In the federal court case, the policy was rescinded. Meanwhile, plaintiff Roberts Orthopedics sued defendant, and defendant denied plaintiff's claim by stating that plaintiff was barred due to fraudulent statements or misrepresentations. Following the entry of the summary judgment order in the federal court case, defendant filed another motion for summary disposition in the Roberts Orthopedics case, arguing that because Boyd's policy was rescinded, neither Omar nor plaintiff were entitled to benefits. Conversely, plaintiff argued that defendant failed to present any arguments that the equities favor rescissions on Boyd's policy as to plaintiff's claim, and the trial court granted defendant's motion. Now, moving on to the appeal case, the Court of Appeal once again first addressed the issues of assignments, just like it did in the Michigan Spine and Brain case. The court made several good arguments. When an assignment occurs, the provider and assignee stands in the position of the assignor, possessing the same rights and being subject to the same defenses. That's the Burkhart v. Bailey case. The court also noted that because the assignee stands in the shoes of the assignor, the provider assignee only possesses whatever rights the assignor would have to collect past due or presently due benefits from the no-fault insurer. And lastly, if an insurer's claim is substantively barred on the merits, any derivative claims necessarily fail as well. That is the Dawood v. State Farm Mutual automobile insurance case. Of note, the Court of Appeals seems to address the issue of assignments first because the privy of an assignment is what the basis of the parties' arguments are. If there is no assignment, there is no privy. And therefore, the provider plaintiff doesn't stand in the shoes of the underlying claimant. Next, the Court of Appeal addressed the issue of res judicata again. Plaintiff argued that res judicata did not apply because the federal court in the Omar case ruled on a different claim for no-fault benefits. But the court once again reiterated the res judicata elements. 1, if the prior action was decided on the merits. 2, both actions involved the same parties and their privies. And 3, the matter in the second case was or could have been resolved in the first. Here, the court said that orders of summary disposition are adjudications on the merits. That motion for summary judgment in the federal court case was an adjudication. The court addressed the issue of assignments. Assignments equal privity. And obviously, both claims arise from the same accident and the same insurance policy. Plaintiff's claim indeed could have been resolved as a part of the Omar PIP claim because plaintiff's claim was that Omar was entitled to receive no-fault benefits. It's important to note that the federal court in the Omar PIP case concluded that Omar was not entitled to any no-fault benefits because, in part, the equities balanced in favor of rescinding defendant's policy with Boyd. Consequently, Omar's claims for PIP benefits, which was premised on the same policy, were barred on the merits, and any derivative claims, such as plaintiff's Roberts Orthopedic Services claims, must also fail. Ultimately, the Court of Appeal held that the trial court did not err in granting summary disposition to defendants based on the res judicata doctrine. Because plaintiff's claim was barred by res judicata, the court indicated that it did not need to decide whether a balancing of the equities regarding rescission was appropriate because the underlying contract was rescinded and thus it legally never existed. As such, the court did not even address the rescission issue here, nor did they balance the equities any further, and therefore the trial court's order granting summary disposition in the provider case was affirmed. All right, and lastly, for our case law update, we have the case of Midwest Medical v. Liberty Mutual Insurance Company. This case does not have anything to do with res judicata, but it does address the issue of authority of a trial court. Here, a plaintiff appealed the trial court's decision to dismiss its complaint with prejudice, and the Court of Appeals affirmed the trial court's decision. As a brief background on this one, of course, it's a motor vehicle accident, and the underlying claimant went on to treat with Midwest Medical. Midwest Medical then sought payment for the services it had provided from Liberty Mutual, and Liberty Mutual denied payments of those benefits. Midwest Medical goes on to file suit and also obtained an assignment of rights from the underlying claimant. In the month leading up to trial, Midwest Medical filed a motion for summary disposition and a motion to compel some depositions. However, both were denied as they were deemed untimely by the trial court. Then, on the very first day of trial, Liberty Mutual made an oral motion for a directed verdict or for summary disposition, arguing that Midwest Medical couldn't meet its burden of proof. After oral arguments from both sides, the trial court held that Midwest Medical was precluded from calling its billing manager to testify because she was not listed on the witness list, and also held that Midwest Medical failed to present a witness who could testify as to whether there was a valid contract of no-fault insurance, which is, of course, an element that must be proven for entitlement of PIP benefits. The trial court did acknowledge that Midwest Medical intended to call the Liberty Mutual claims adjuster. However, the subpoena was not valid. The adjuster was not notified of the subpoena, I believe, until the morning of trial. So the court held that that was not a valid subpoena. Then the court dismissed Midwest's complaint with prejudice, and the appeal followed. Midwest attempted to challenge the trial court's decision on two issues. First, the issue of abuse of discretion, and then the trial court's decision to dismiss plaintiff's complaint. With regard to the abuse of discretion, the Court of Appeals noted that a trial court has the inherent authority to control its own docket and internal affairs. That power is not governed by rule or statute, but by the control necessarily vested in courts to manage their own affairs, so as to achieve the orderly and expeditious disposition of cases. The court also noted that with respect to the trial court's decision to decline to consider plaintiff's motion for summary disposition, under MCR 2.116b2, a motion for summary disposition may be filed by a party at any time. However, the court rule does not deprive the trial court of the discretion to set a limit on the time for which a motion can be heard. Here, discovery closed some 6 months before defendant filed its motion for summary disposition. And that was 1 day before trial that the motion for summary disposition was filed. The specific trial court in this matter, the order was that a motion for summary disposition must be filed at least 60 days prior to trial. My apologies. Midwest's motion for summary disposition was actually filed approximately 1 month prior to trial, but still in violation of the court's order requiring that it be filed 60 days. Additionally, with respect to the motion to compel the depositions, that was also filed 1 month before trial and almost 6 months after the close of discovery. Ultimately, the court held that the trial court's decision to decline to hear plaintiff's motion was not an abuse of discretion, as it is under the trial court's authority to make its own scheduling order. Now moving on to the trial court's decision to dismiss plaintiff's claims. Plaintiff Midwest argued that it was not clear as to what authority the trial court relied on to dismiss its claims with prejudice, only that Liberty Mutual appeared to request that the trial court grant dismissal based on lack of evidentiary support. Under MCR 2.116I1, if the pleadings show that a party is entitled to judgment as a matter of law, or if affidavits or other proof show that there is no genuine issue of material fact, the court shall render judgment without delay. As such, the Court of Appeals also concluded that the trial court did not err by dismissing Midwest's claims based on its conclusion that Midwest could not establish a prima facie case. In order to establish that it was entitled to relief, the plaintiff, Midwest Medical, had a burden of proving that there was a valid policy of insurance and that its charges were payable. Midwest had to establish that the charges were incurred, which required a showing that the underlying claimant had become liable to pay Midwest and that Midwest had expected compensation. Midwest was unable to do that on the first day of trial. One, Midwest was unable to authenticate Liberty Mutual's claim file because it could not call the adjuster, as they did not properly subpoena the adjuster. And also, Midwest could not present its bills because the underlying claimant was precluded from testifying through deposition or at trial because Midwest failed to notice the deposition in a timely manner. As such, the trial court did not abuse its discretion by dismissing plaintiff's complaint. The trial court also goes on to discuss MCR 2.401I1 that requires that all parties file and serve witness lists within the time allotted by the trial court. Plaintiff here did not list the underlying claimant on their witness list. So ultimately, the Court of Appeals concluded that there's a number of reasons why plaintiff's claims should have been dismissed, were properly dismissed by the trial court, and that there was not an abuse and discretion of the trial court not allowing plaintiff to file its motion for summary disposition or motion to compel depositions. Moving on to trending topics in PIP litigation, I wanted to discuss the scope of chiropractic practice pursuant to MCL 333.16401 and MRIs. Generally speaking, services that fall outside of the scope of chiropractic practice are not collectible. Under the No Fault Act, PIP benefits are payable for medical expenses that are lawfully rendered reasonably necessary for an insured's care, recovery, and rehabilitation. As an exception to this rule, the legislature enacted 2009 PA 222, which added MCL 500-3107BB to the No Fault Act. It provided that reimbursement or coverage for expenses within personal protection insurance coverage under MCR 500-3107 is not required for any of the following. Of importance to this discussion, is not required for chiropractic services unless that service was included in the definition of practice of chiropractic under MCL 333.16401 as of January 1st, 2009. Now, the definition of the practice of chiropractic means that discipline within the healing arts, which deals with the human nervous system and its relationship to the spinal column and its interrelationship with other body systems. Practice of chiropractic also includes diagnosis, including spinal analysis to determine the existence of spinal subluxations or misalignments that produce nerve interference, indicating the necessity for chiropractic care. It also discusses chiropractic adjustments are within the scope and the use of analytical instruments, nutritional advice, rehabilitative exercise, adjustments apparatus, use of x-ray machines in the examination of patients for the purpose of locating spinal subluxations. It specifically notes that the practice of chiropractic did not include the performance of incisive surgical procedures or the performance of invasive procedure requiring instrumentation or the dispensing of prescribing drugs or medicine. So, not mentioned in this definition of what is included in the scope of chiropractic practice are MRIs. That was specifically discussed in the case of Hoffman v. Auto Club Insurance Company, where the Michigan Court of Appeals considered whether expenses for various products and services a chiropractor rendered to a claimant during the course of chiropractic care were subject to payment as no-fault benefits. The court in Hoffman also explained that merely because an activity is excluded from the statutory scope of chiropractic does not mean that it is unlawful. The court then considered several different services and activities and whether they were within the statutory scope of chiropractic practice. The court held that orthopedic and neurological examinations of non-spinal areas and the use of hot and cold packs were outside the scope of chiropractic practice. Again, the scope of chiropractic practice, or the definition of the practice of chiropractic, makes no mention of MRIs, but does specifically address the use of X-rays. As such, as the statute existed on January 1st, 2009, chiropractors are limited to only ordering X-rays for the purpose of locating spinal subluxations or misaligned vertebrae in the human spine. Now, a lot of times in litigation, we see that a chiropractor has gone on to order MRIs. So that is what's specifically addressed in the Hoffman case. According to MCL 500-3157, any treatment rendered to an injured person must be lawfully rendered. If a chiropractor prescribes an MRI and the plaintiff or a provider is seeking reimbursement for those services, that is not lawfully rendered, as it falls outside of the scope of chiropractic practice. As such, on motions for summary disposition, the defense has been arguing that the services and MRIs are not compensable as they were not lawfully rendered. In contrast, plaintiffs have been arguing that the services were reasonably necessary and therefore defendants must pay them. And sometimes those arguments have been successful in a number of courts. We have seen some recent successes with these types of motion as of lately, and even some appellate success after a district court has denied this type of motion for summary disposition. Ultimately, I believe these types of motions for summary disposition are worth filing and definitely worth arguing because the statute is clear here. Case law is very clear as well that these services, MRI services specifically, fall outside of the scope of chiropractic care. It's mentioned, X-rays are mentioned several times, and in the Hoffman case specifically discusses that MRIs fall outside of the scope of chiropractic care. And that is all I have for you today. Thank you all for attending the February 2021 episode of my PIP Monthly. Please feel free to contact me with any questions or concerns. Again, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office.